Hi, this is Curt Barone, and we're here for a special edition of Fire Law Vlog. And the reason for it is there's been some cha not changes, but some areas that's worth us talking about with regard to the FLSA. And we've been Bill and I, my good colleague and friend Bill Maccarone, have been talking about some of the changes. And I think it's been a while, Bill, since we really talked about some of the changes that are evolving with the FLSA. So,
Yeah.
uh, and you've really got your pulse on it. I lean on you heavily when it comes to what's going on with the FLSA. So, what are the changes that we got to look forward to?
Yeah, well, it's kind of, well, thank you for the opportunity to come on here and discuss it. There's been some I don't want to say unusual trends because as you know, we both follow, the litigation when it comes to the FLSA, and there's usually no shortage of litigation when it comes to the FLSA, and those continue to trend forward. But I just was thinking and kind of looking back over the last year, and obviously we have our usual regular rate cases. The litigation related to regular rate is just kind of like just the drum that just keeps beating. It's not, and as you know, it's probably the most likely reason someone's going to get hauled into court in the event of an alleged FLSA violation is that a violation, alleged violation of the regular rate, which in turn is going to impact a firefighter's overtime rate and a firefighter's their regular rate for comp time, things like that. So obviously that's a
Well, I
standard.
hate to derail you, all right, but I got a question on that. So,
Yeah.
is are they suing for the regular rate, or are they suing for something else and throwing in a regular rate
Well,
issue issue and just taking advantage of that regular rate issue in addition to the other things that they're suing for?
it's a combination, but that's a pretty astute observation because I think that is absolutely the case very often.
Mhm.
Sometimes that a violation will get the foot in the door, a regular rate will kind of get their foot violation will get the foot in the door, and then additional claims come in on top of that.
And what are the additional?
As far as
Well, are they
additionally,
like I know we covered a couple of cases. It was a couple of years back, but it had to do with shift overlap, and I haven't seen much of that. But would that be an example? So they're suing on shift overlap, and then they stack on top of that like a regular rate.
absolutely.
Uh,
Yeah, no, absolutely. And you have that off the clock type of a claim that will have that you'll get the regular rate aspect to it. A lot of times, not as often with firefighters, but it occurs with single role medics and dispatchers and folks, mostly single role medics. There'll be a off the clock type of claim because that is a definitely an emerging issue in fire service when you have the single role medics, especially
mhm,
and because of the number of overtime hours that they're working,
mhm,
as normally are working.
mhm.
And you'll have that off the clock claim, and there'll be a regular rate component to it because now all of a sudden there's all these additional hours of overtime in theory that the employees or the paramedics or medics going to be eligible for.
Hmm.
But no, I do think that that's a good point. That a lot of times it is you're seeing these claims stack on top of each other, and regular rate is certainly one of them.
Yeah. I think sometimes folks, I put it in my emails that it's the biggest, uh, it's the law with the biggest impact on the fire service. And folks I don't think they appreciate that, but I ask them in class sometimes to say, what would staffing look like in your department if you didn't have to pay overtime? And you didn't have maximum hours. What might staffing look like? How might pay and different things differ? And when you think about it that way, it's a huge impact on career departments, and the same in volunteer departments as well. Because if
Oh,
if you didn't have to worry about inadvertently creating an employee, you could give volunteers whatever you wanted. Think of the things that you could do, but it's the FLSA that puts the kibosh on both of
absolutely.
those.
Just hourly compensation. Think of just that. Just if you're, if a volunteer organization could pay a volunteer or compensate a volunteer on an hourly basis, even a low basis, not even saying, you're gonna make 20, 30 bucks, 40 bucks an hour, but you're able to pay by the hour. Just think
Yeah.
of that one small nuanced change that probably
And
would change the landscape.
and related to that, if you could pay them one day and then let them volunteer the
Yes.
next. You can't
No,
do
you're
that.
absolutely right.
You're absolutely it's kind of like being pregnant. You're either are or you're not. You're either an employee or you're not, and
Yeah.
you can't be an employee one day and a volunteer the next day,
Yeah.
at least within the same work week or work period.
Yeah.
So,
No, it's very true. Very true.
so
So beyond the regular rate,
yeah, yeah,
the
that's
next thing, and this is something that it caught me a little bit by surprise because in the last couple of months, there have been four lawsuits that I'm aware of, and I'm sure there's probably a couple more out there that I've missed.
mhm.
There's at least four lawsuits that I'm aware of over executive exemption and battalion chiefs.
Oh,
And that's it's kind of an ebb and flow. You'll go a period of time, you'll see a couple, and then you'll kind of see it slow down a little bit. And now you see it
mhm.
pick up again. But we've
That's
got
interesting.
everything.
You say battalion chiefs because that's what you used to be,
Oh yeah, no.
and now you are no more, right?
So now I'm pro employer on that topic. No, I'm joking, but no, I think in it's running the gamut on the battalion chiefs cases, and I just did a quick search just in the last 6 months or so on my website, and we've got West Des Moines, Iowa, which is not a huge department because good sized department, and you got FDNY. So you see, we're kind of
Oh, we got an executive exemption case
yeah
out of
out of
FDNY.
FDNY, yeah, with
Oh,
battalion
really?
chiefs, yeah.
Oh, really? Oh, how did I
So and
miss
you got
that?
Louisville,
Bill,
Santa Fe, New
you gotta let me
Mexico.
know when you see it. I try to stay on top of these. I didn't see the FDNY one.
Yeah. Yeah,
It's
it's a
not
couple months
by me.
ago.
Yeah.
So you look at that, we're definitely seeing a little uptick just in the last couple of months over that. Additionally, this past year, I'm aware of two settlements on that topic where you had battalion chiefs in Osceola County in Florida and Milwaukee settled
Mhm.
lawsuits regarding battalion chiefs. And
Mhm.
unfortunately it was district chiefs down in Orlando, the court dismissed their claims. But that's getting appealed to the 11th Circuit. So that's
Yep.
not over yet. But it's certainly it's more or less it's making its way through. I imagine that's going to take a while if to kind of
Well,
make
as
it.
you're doing that, I want to
Yeah.
just go back and take a look at my database. I'm just doing a search now of executive exemption for chiefs,
Oh, okay.
and I want to see how many recently, because I think you have more than I do, because I'm looking at broadly at a lot of different topics.
Sure.
And, I try to follow your blog, and I basically poach the ones that you get for me, and I put them in my database.
Yeah,
But
absolutely.
I've got Santa Fe.
Yeah.
Okay, that one. I've got Louisville.
Yep.
FDNY. I did have that one. I'm
Mhm.
sorry. I apologize. See, remember we're talking about forgetfulness, right?
Absolutely.
I actually, it's in my database.
Good.
I don't have a recollection of actually putting it in there, but it's in there. Osceola County,
Yeah.
um, Milwaukee,
Yeah.
Milwaukee.
And that's all from
That's
I
2024.
but I
That was,
think the set okay, so it was 24. Okay. I had it
oh,
down
it's
in
settled.
mine
Yes, it is
as
settled.
early
Yep.
25.
Yeah, yeah, but it's settled. Yeah. Yeah, so that's actually quite a few.
Yeah,
Um, yeah, and I think there's probably more that we're
I
missing.
agree.
But me more so than you. Did you have others besides the ones I
Those
mentioned?
are the I did a quick no, that's what I had when I did a quick
Okay.
look back here to
How
see
did
what
I
we
not
got.
know that FDNY case?
Well, that's not that long ago, if you recall, I came across a Los Angeles City settlement for almost $10 million, and I about fell off my chair and said, "How could I have missed this?"
Yeah.
And I spent about an hour writing a post, and then I realized I had already covered it three
Uh,
months earlier.
well, it's gonna get worse as you get older. So, but
So,
yeah, I entered that in June
yeah, okay.
28th. So there you go.
What else is going on? So
Yeah.
there's some DOL news. Oh, I don't know. Do you want to continue to go on the
Yeah.
executive
No. No.
exemption? All
No.
right,
No. No.
there's
Just
also there's some DOL news with the new administration coming in this year with the Trump administration taking over the Department of Labor from the Biden administration. So folks that are not aware, the Department of Labor is part of that executive branch. So it's kind of like we try to use the analogy, it's steering a battleship or an aircraft carrier.
Mhm.
And if depending on who's in office, the ship kind of steers in a certain direction, and then someone else comes in and
Mhm.
the ship will veer back in a different direction. Although in these times, I think the ship is doing full,
It's like a speedboat.
yeah, they're doing more than just a 180. Sometimes I think they're doing literally a 360, but there are some changes coming which are important, I think, for employers, for fire departments, and I think firefighters to an extent, because litigation always isn't the best answer, as we know.
Mm,
Like,
yeah.
hopefully you can settle it and figure it out. You realize there's a mistake been made, you can kind of rectify it, pay people the money they owed, and move forward. That's best for everybody involved, obviously, for
Mhm.
for obvious reasons.
Other than the attorneys, but
Yeah, well, I hate to
yeah.
say that, as that's, but that's the reality. If you can, but then sometimes you
Yeah.
can't, and then
Yeah.
you gotta, parties have to do what they have to do.
Mhm.
But the Department of Labor has brought back two interesting things, and the first one I'll touch upon is opinion letters, which we like opinion letters because
Yeah.
opinion letters are, for folks that are not aware, you can petition the Department of Labor and kind of give them a fact-based scenario from your organization, and you want to get a opinion as far as the Department of Labor of how they would enforce the FLSA regarding that particular, or the FLSA or the Department of Labor regulations for that particular subject or topic. The first opinion letters came out at the beginning of this year, a few months ago,
Mhm.
and it actually involved a firefighter, and it involved regular rate, or not a firefighter, but a fire department, and a fire department that was paying folks a wage augment, which is additional money for something. In this particular, it was like a emergency type of call pay that they provided, and the employer was saying, do I have to include this in the regular rate, or can I exclude it from the regular rate? And the positive on these types of things is you kind of get a good feeling of where you stand, and it's always good if you can look at it and say, okay, well, here's a fact pattern very similar to mine, as an employer, or even as a labor union or a group of firefighters, to say, this is very similar to what we have here. Look at this paper that I have from the Department of Labor, and this is how they're going to interpret the FLSA. And I do think it's a helpful tool. And very often the court will look at that and view that as, yeah, this makes sense, and they'll give that a degree of deference depending upon. I know we talk about this for a little bit in the 24-hour class, where sometimes the courts give an opinion letter a great deal of deference, which means they're going to
They
look at it and they're going to follow it.
Whenever they agree politically with the decision, they give it a great deal of deference. And whenever they disagree politically with the decision, they go against it. Yeah. So
There's been those times, unfortunately,
yeah.
but I do think it's a good tool. It's a good way to kind of get the word out as far as what the requirements are of the DOL regulations and the FLSA. So that's kind of interesting that the
Well,
DOL has started those up again. They had suspended them for the last 4 years
and that's what I
under the
want to
Biden
talk to you. I
administration.
just was thinking, I remember President Obama stopped doing them.
Yeah.
And he actually canceled some of the ones that had been issued by President Bush back
Yes.
in his initial years. They stopped doing them for 8 years.
Yeah.
Trump started them again. So, which is kind of, I'm not sure, how the politics, why Republicans would think it's a good idea, because there's certainly those opinion letters are not anti-labor by any stretch. They're certainly
No.
not all pro-management. So, and then Trump started them, then Biden stopped them again,
Yeah.
and then now
Yep.
Trump is
And
starting
now
them
Trump
again.
started them back up. Like I said, it's the aircraft carrier. We're
Yeah,
going left, we're
really.
going right. Literally, we're going left, we're going right.
Yeah. I don't think I follow that one, but
Yeah.
it is what it is, I guess.
The
Yeah.
other program, which is definitely not a fan of plaintiffs' attorneys, is the paid program. The paid program is back, which the paid program is a program that the Department of Labor offers, and it's the payroll. Hang on, I had to write it down because I knew it was going to. It's the Payroll Audit Independent Determination Program, otherwise known as PAID, PAID. And the reason why plaintiffs' attorneys really don't like this, and I understand, is if you're an employer and you feel like you're making a mistake, you can more or less reach out to the Department of Labor and say, listen, we think we're making a mistake here. We want to fix it. And there's a trade-off here. The trade-off is, if the Department of Labor takes your case, so to speak, or entertains what you're bringing them, they're going to send you some information that you actually, the employer, conducts an audit, and the employer looks with some assistance from the Department of Labor at the last 2 or 3 years, and I believe it's two. I think they keep it at 2 years, which makes sense.
Mhm.
And then the employer submits these forms. They determine whether or not they owe money. They submit it to the Department of Labor. The Department of Labor looks it over, confirms it, and then actually drafts individual agreements for the employees that are involved, where you sign you in theory you're signing away your right to sue over that,
Mhm.
but you get 100% of your back wages, no damages,
Yeah.
but the employer has to pay that within, I believe it's 15 days.
Mhm.
So it's a quick, it's a quick
Right.
turnaround. So
But think of the benefits to there's benefits to the employee as well, because if
oh
they've been
yeah,
shortchanged, you get it fixed, and then going forward, you're fixed. So it's not all pro management. There's an advantage
exactly.
to the employees, and now you don't have the headache of 6 years in federal court banging heads.
Exactly.
And so I think there's benefits on both sides. I don't think it's just pro management. It's actually
No.
pro employee.
Well, there is an advantage for management because they're going to avoid that double damages. They're
Right.
going to avoid the potential of 3 years.
Yeah.
Like I said, the folks that really hate it are the
Yeah.
plaintiff's
I
attorneys.
can see that.
Exactly.
I
That's
can
the
see that.
real, but I agree with you that
You know
there's
what?
something
You know what? The defense attorneys for the municipalities may
that's
hate it.
true
The
too.
outside counsel may hate it as well because they're getting kind of cut out of their piece of the
That's true.
pie.
That's
But
true as well.
yeah, but I
And
think
I and
we're all better off. I think municipalities are better off. The firefighters, I
yeah,
mean, yeah, okay, you're not going to get the damages, but when there's $4,000 worth of damages, and even if it gets doubled, it's $8,000.
yeah,
The big ticket item is the attorney's fees that are
yes,
$200,000 on each side,
absolutely.
So that's your big ticket item, and you're cutting out that part of it.
Yeah. No, you are. So that is and I think that that's a pretty that's an interesting development. I think it's a positive development
Yeah.
overall. I understand why, like I said, some of those plaintiffs' attorneys don't like it, but at the end of the day, and I think and I think the after speaking to folks that really don't like this program, a lot of it they're thinking that it's almost the ability for the employer to kind of get away with taking advantage of an employee. And I'm sure in some unscrupulous circumstances that
Mhm.
absolutely could be the case, right? And
Yeah.
there's one caveat to the paid program I got to be very clear on is you can't be involved in litigation in order
Okay.
to
So
enter into it. So
yeah,
it can't be, you can't as the employer get a letter from the firefighter's attorney to say, hey, we're suing you, and then run down to the Department of Labor and say, I want to
try to
go
beat
into
them.
paid
Yeah.
program, which makes sense. It totally
Yeah.
makes sense. But
Yeah.
I think that unfortunately, there probably are some unscrupulous employers that would look at it that way. But I
Right.
think there's also a lot of very, concerned employers that are just kind of overwhelmed, made some mistakes. It's a little confusing. It can be challenging and look at it. And I know when I deal with fire departments, particularly, I've yet to hear a fire chief say to me, I just want to try to, get over these people on this and try to get,
I try
screw
to.
them out of money.
Yeah.
That's not what you hear. You hear, we want to do what's right. We want to take care of our people. We want to do what's right. And we want to fix it. We want to move forward.
I,
And this gives them that
I've
opportunity.
I've counseled a number of departments over the last, I'd say, 2 years in particular, who've been driven by software to change the way they're doing calculations.
Yeah.
And that in and of itself has created problems because the software company, they promise you the moon. They say, oh, yeah, it'll do everything, it'll do everything. Well, and then it doesn't. And
No.
now you've got a problem. And I don't know. I think maybe the paid program, as long as litigation hasn't been threatened, but it may offer a solution there where maybe you were doing everything right.
Yeah.
Now all of a sudden you get this new payroll company coming in and it's not right. And
Yeah.
so now you let the DOL figure out, all right, this is how it's got to be done. You work in conjunction with the DOL.
Sure.
Now the payroll company has got to get with it, or else there's got to be some responsibility on their part for not doing it the way the Department of Labor says you're supposed to be doing it.
Yeah. No, exactly.
So,
Exactly.
yeah.
And the only other really, well, I guess there's plenty of things we
Well,
could talk about.
well, I get before we, because I don't want to
Yeah.
run out of time here on this one. Overtime. Now I know it's not an FLSA per se issue,
Yeah.
but no tax on overtime.
Yeah. Yeah.
So, well, I
That's
got a question for you. What is overtime?
well, according to the,
If I get time and a half on a Sunday for working a Sunday, or I get time and a half for working a holiday, is that overtime?
no, well, not necessarily. And if
Okay.
you look at the big, beautiful bill, I think that's what we call it.
Yep.
And if you look at that, it's it's federally required overtime.
Okay.
So for an average worker, an average person that works a 40-hour week, that's pretty straightforward, I think, or it's a little easier to keep track of what that actually is. For a
Hmm.
person that literally doesn't get any overtime, until they work over 40 hours a week. But now you put this FLSA overtime on a 7K firefighter where you could be as high as 212 hours in 28 days or maybe 24 days, like depending on, I think it's what 192 on 24 days, whatever the standard is. And then
Yeah.
on top of that, you say, okay, but if any work outside of your scheduled shift is time and a half, that's not uncommon
Yeah.
in the industry. Maybe you've worked all your shifts in that work period. Maybe you were on vacation for a couple of days. Maybe you missed a day for you're out sick or whatever. How are we going to keep track of that? I think is the devil lies in the details in that
And
one.
that's not going to fall on the firefighter, and it's
No.
not even going to fall on the fire chief. But I can see payroll people
Yeah.
losing their minds over this.
Yeah.
Is that going to have to be on their W-2? Like how
Yes.
much?
The way I
Oh my
understand it, and I'm
God.
no expert in this, and I think a lot of the
It's really an
issues when
IRS issue. I
yeah, but when it
get it,
first
but
came out, it came out, but there was very little details behind it. And you were
yeah.
really relying, read this. And I was reading all these different articles to try to see if I could get to the bottom of it. And there was very little guidance, coming out of the government on this. What is clear, though, is it is just on federally required overtime. And the tax credit, so to speak, or the part that's tax free in theory is the halftime. It's not the
Oh,
1.5, it's the halftime.
uh-huh.
And there needs to be an additional box on the W-2 next year to
In,
show that number.
oh wow.
And that's where it gets, like I said, I'm not an expert on this, but that was the takeaway where
Well,
I just, because I
you
don't think
know,
many,
you know what it takes to do the calculations to figure out what is FLSA overtime versus contractual overtime versus
yeah,
other types of overtime. So you and I know what it takes to do that, okay? And it would take us, it'd be laborious for us to do it.
yeah,
I wonder what, for example, if the municipality takes the easy way out and just counts all of their overtime hours and puts that number in the box, okay, how the IRS auditors are
sure.
going to go about debating or disputing that
Yeah.
because they don't have the expertise in trying to figure out that. And imagine the calculations they would have to do to try to get that right.
And if the employer provides it, I know if the employer provides an inaccurate W-2 and then a person
Mhm.
goes and does their taxes and then they come back in March or in June or whatnot and say, "Oh, sorry,
Yeah,
we made an error," which can happen, but
yeah,
here's the real W-2. How do you go about rectifying that and
yeah.
remedying that?
What a nightmare. Wow.
Yeah. So those are, and like I said, I'm not an expert on that in any means, but those were the takeaways, the three takeaways that I took that I said, wow,
Mhm.
this is going to be really challenging.
Yeah.
And I don't know, I'm sure that different systems pay their overtime in different ways,
Mhm.
but I've never heard or I've never seen a program, at least my organization, we don't have here's all your straight time earnings. And then on top of that, here's your halftime earnings. We
Mhm.
get the straight time and then under it is overtime and it's represented as 1.5. And it's not, I mean, it's not, I think that's the standard. I'd be interested to see if there are places out there that,
Now, is this going to take, is it going to apply to the 2025
okay.
taxes or is it going to start with 2026?
I believe it's going to be it's going to be done
This
for this January.
this January.
Yeah,
Wow.
this, I guess what, by the end of January is when those
Yeah.
the
Wow.
documents are out.
It'll be interesting. It'll be
Yeah.
so another round of litigation I foresee,
Yeah.
coming at us. So
But no, it's definitely challenging. Definitely challenging.
super.
And
Well,
like I said, we can go on and on, but I do have one more topic if we have time. I
yeah,
think we're
yeah,
just
yeah,
right.
yeah.
There is an emerging trend. I mentioned the emerging trend about the EAP lawsuits. There's also an
Uh,
emerging trend where you're seeing a lot of departments starting to implement Kelly days, and they're starting to put Kelly days into their schedule. And a lot of departments are starting to shift from three platoon type of a structure to a
mhm.
four platoon structure.
Yeah,
And there's a lot of FLSA implications, as both of
yeah.
us know. There's a
Mhm.
lot of FLSA implications in doing that. So I've seen an uptick, and certainly not on litigation. I haven't seen any litigation on this topic, but because what it is it's a trend in the service.
Yeah,
That
I don't
takes.
think it's driven by litigation. I think it's being driven. And several of my clients, particularly out in the Midwest,
Yeah,
they are directly competing for personnel, and they're losing people from their department. People are leaving their department. We're talking about experienced people with 6, 8, 10, 12 years. They're leaving Department A to go to Department B, which has gone to the
a 42
basically
hour work week or a
four
48
shift,
hour work week. So yeah,
whatever the numbers work out to, but
sure.
they're going from a three shift department to a four
Yeah.
shift department, and they're working fewer hours and getting even sometimes even more pay.
Yeah.
And so now it becomes competition that departments have got to go to four shifts in order to be able to not lose people or be able to attract
Yeah.
people. And
What I
that's
meant by that, I
yeah,
apologize, it was
yeah,
confusing. I meant that not that there's litigation isn't necessarily driving it, but what I meant is that I'm not seeing any litigation in that area because it's
yeah.
just starting to kind of unwind. And I don't, I think sometimes there's this misnomer. I like to just if someone works a 50-hour average work week
Mhm.
and you publicize 50-hour average work week, you think, oh, okay, well, you don't have to be calculating overtime if that person doesn't come in and work any extra shifts.
Mm.
But as we know, when we start to average things,
Mhm.
very rarely is it really, there's going to be work periods where absolutely the employee might be under 50, but there's
Mhm.
going to be several or at 50 or under 50, and there's going to be other work periods where that employer is going to be over. So you still have to be maintaining that,
Yeah.
those
Well,
calculations.
that's right. You got to like just like you and I have to do, we have to take out our calendar and
Yeah.
plot out the different shifts and things and figure out is this particular work period, is a 14-day work period going to result in a possible one cycle here that they're going to be entitled to overtime,
Yeah.
even if they don't work any extra hours. So,
Exactly.
this is what Brian
Exactly.
says. Brian, I love Brian saying that if you found an easy way to do it, you're probably doing it wrong.
Yeah. I think he doesn't say probably. I think he
No.
says, but you're correct. That's his line. If it's easy, it's wrong.
Yeah, it's easy, it's wrong. So, all right. Well, Bill,
But yeah,
thank you. And I again, for those who've been following us on our FLSA journey, we do have two classes coming up. Two of our in-person classes. We've got one in DeLand, Florida, December 9 to 11, I think it is.
yes.
And then we're going to be in Houston, Texas, down there after the first of the year, February 3rd to the 5th, I think it is.
Okay.
Yep, down in Houston, Texas, and we got big classrooms in both of them, so plenty of room. DeLand, I was down there for my discipline class earlier this year, and really a great venue down there, great hotels, great restaurants, easy in, easy out. A couple of different airports you can get there, so we're looking forward to Florida in December
Yeah,
and
that will be nice.
Houston in February. So
That will be nice.
that'll be great. And then we've got a couple of webinars and things on specific targeted areas on the FLSA. So we hope you'll join us. And Bill, thanks for coming on. How we
Thank you.
liking our new job?
It's good. It's good.
Assistant Chief
It's
of Department,
it's an adjustment, but it's a good adjustment.
5 days a week. I hated it. I absolutely hated it.
Well, I appreciate you doing this at 5:40 in the evening.
No, not a problem. Not a problem. That's all good information, Bill. All right, and we'll see everyone for the next edition of File Law Roundup on Monday. And actually, I think we may be doing another vlog tomorrow if everything goes right. So I got a vlog scheduled with Brad tomorrow. So
Excellent.
we will
Thank you.
see. All right, Bill. Thank you.
We'll see you.
Thank you. Okay, bye bye.